Morning, Mayor. Please, the court attorney, Damien Cash, P number 85852, on behalf of Mr. Taylor Byer. Mr. Byer, state your name for the record.
Taylor Martin Byer, Your Honor.
All right. State and time for sentencing. Have you reviewed the report?
Your Honor, yes, we've reviewed the PSI report. I have no additions or changes or deletions, Your Honor. I just do at some point want to discuss the bond violation that Mr. Byer had in the report that I recently received.
All right. Well, go ahead.
So, Mr. Byer, I called records at Bear River Treatment Facility in roundabout Traverse City area. He was admitted for treatment on November 24th. That is the reasons and the explanation for why he was not able to test. I do understand that he was in contact with, at times, the probation department to inform them that he was in treatment. I'm not exactly sure how those conversations detailed. However, he was in treatment. He completed December 23rd, and they confirmed the records to me this morning, and I also reported those records to your court as well, Your Honor.
He completed Bear River.
He completed Bear River, yes, Your Honor.
I think I'm not going to find a violation because I think that the issue is potentially that there wasn't a release information. It wasn't anything that this gentleman did. I was a circumstance where information was just not flowing
Back and forth.
yes, like it should have been. So I'm not going to find a violation of that.
Thank you, Your Honor.
Doesn't seem to be a violation. He's in treatment. So, all right.
He owed him some flowers and candy, as I promised him this morning for his record.
Okay. Okay. Anything else?
Other than I'll just briefly allocute. I've been in contact with his family, his brother, and they informed me along his siblings. They are, I would say, very interested in seeing his growth and his continued development as he continues to go through treatment. I believe it is very serious to him, as well as he's admitted to himself. He's explained to me multiple times that it is very serious to him to get through this treatment process to better himself, and that really he just want to get back to being a productive citizen and back to work, Your Honor.
Yes, Your Honor. Sir, anything you want to tell me?
A sentencing calendar moves fast, but the consequences last a lifetime. One judge, one courtroom, and a series of decisions that will shape what comes next. Here, accountability is measured case by case.
I want to say thank you for everything you did, because it actually helped me in my life to get my life on track. And I only want to do the right thing. I want to be the best dad I can be for my son. And I just want to be the best person I can be. And I just want to say thank you for helping me with my journey, because I'm on the right path. And I just want to say thank you.
You're welcome, sir.
Thank you.
Ms. Blair, just so that I can make sure I'm understanding this, the proof of treatment.
Your Honor, I was not able to obtain that information because there was no release of information.
Got it.
However, it was brought to my attention when Mr. Byer was arraigned that he advised the court that he was in treatment, and they had something of attendance but no completion. So I know he represented that he would complete it. I just was not able to.
Right, and I think.
Can I say something?
Was this the one that we received that indicated that, or was that another one?
Whenever it was another.
Was another one. Okay. I guess I don't have the proof of the treatment yet myself, but
last week when I was here, I gave my completion to Judge Reese, and I actually have my completion in my file.
You gave it to who?
Judge Reese. Is that her name?
Well, we don't have a Judge Reese.
Oh. I gave her the copy last week and they made a copy of it. It's actually in my folder.
I was to say, that's from Bear River.
Yes.
The records I received today will be the most, I'll say, up to date records that was released this morning, Your Honor. And hopefully that is enough to, because it states on there.
Well, which records are you talking about? I actually have it. I see the verification of the discharge letter from Bear River. I see it now.
Okay.
Indicating that he has successfully completed the program.
Okay.
I have it. I see it. It was one of the other papers that was on there. Okay. And that's the treatment you were talking
Correct.
about. Okay. Very good. All right.
Your Honor.
You're welcome. So I will sentence of the court $125 statutory fee. I'll order 90 days in jail, credit 61 that he served. The balance of that is suspended.
Thank you, Your Honor.
Okay. So I'm changing that. Good luck to you, sir.
Thank you, sir. And you have a wonderful day. Thank you. Thank you. Thank you. Oh, yes, I will. Of course. I will not.
Court calls the case, People versus Wayne Ranken.
Carolyn Foster talking on behalf of Ranken. Can I state your name?
Your name? Wayne Ranken. All right. Go ahead.
And Your Honor, we have had a chance to review the pre-sentence report. We have no additions, corrections, or deletions. We would ask the court to follow the recommendation. Mr. Rankin did indicate that he needs a payment plan for the restitution and the fines and costs. He said he can make a payment by Friday of $200.
Yeah.
And then he believes he should be able to do $200 monthly payments. Is that right?
Yes, ma'am.
Anything you want to say, sir, before I impose sentence?
Just no, I don't really have much. I just take full accountability for my actions. Just made a bad error in judgment at the time. I just got back to working for a Bill property. I was laid off, so that's why I'm not being able to pay anything today.
Sentence of the court, $400 fines and costs, $3,484.87 restitution to the victim in this case payable through the court. I'll order 93 days suspended. As to the payment of the fines and costs and restitution, that's to be $200 per month beginning January 16, 2026. I will set a review hearing that will be June 10, 2026 at 9 a.m. to verify compliance with the payment plan.
Okay.
Wow. All right.
Thank you, Your Honor.
Thank you.
Court calls the case, People versus Deanna Conrad.
Good morning, Assistant Public Defender Lauren Perny on behalf of Ms. Conrad. Ms. Conrad, state your name for the record, please. Deanna Conrad. And today is the date and time set for defendant today. We ask that the court adopt the recommendation that Ms. Conrad has been in custody for quite some time. I would ask for a payment plan to be established with probation on the fines, so she can get out and get back on her feet before starting to pay those.
Anything you want to say, ma'am, before I impose sentence?
No,
And you know why you're here, right?
I do.
You just got to do stuff different,
Yes.
right?
Okay.
The court acknowledges this is not a serious misdemeanor as defined by statute, however, does believe there are reasonable grounds to depart from the presumption of a non-probationary sentence. The alcohol screening and assessment identifies the benefit of outpatient substance abuse treatment, attendance at AA meetings, and abstinence from all intoxicants. Therefore, the court will follow the recommendation of probation for a probationary sentence with the stated rehabilitative goals to promote change, prevent recidivism, and to monitor compliance of recommended treatment. So therefore, the sentence of the court that you are placed on 12 months probation. You're to pay $855 fines and court costs, $100 prosecution recovery costs, $100 police agency recovery costs, $360 probation oversight fees. That is to be paid in a payment plan as established by probation. There is to be no use of alcohol, recreational marijuana, or illegal substances. You'll be subject to random testing as requested by probation. You're to complete outpatient treatment, including all recommended aftercare with status reports to probation. You're to provide proof of the victim's input panel attendance to probation. You're to attend 2 AA meetings per week with monthly verification to probation. You are to report to probation on January 20th, 2026 at 2 p.m. That is an in-person. Right? And then you're to report as directed. I'll order 93 days in jail, credit 47, balance is suspended. All right. Thank you.
Thank you, Your Honor.
Court calls the case People versus Rex Jenkins.
Incarcerated in a facility in Ohio. Your Honor, I do not believe he was writ for today's hearing, but I was able to meet with him and go over the recommendation, and he would be asking the court to follow it even without his presence.
All right. And so you're indicating that you wish the court to sentence him in absentia on this violation.
Yes, Your Honor. And I did speak with him directly yesterday, and he gave me permission to proceed in that manner.
All right. And so he admits to the violations of probation. In absentia, will sentence the defendant to 365 days in jail, credit 365 served. He is to pay $545 outstanding restitution balance that will be sent to our collections department. I will waive all remaining terms, discharge him from probation without approval. Thank you. Court calls the case People versus Leo Stringa. 2 cases.
Assistant Public Defender Natalie Pate, on behalf of Mr. Stringo, stands to my right. Please state your name for the record, sir.
Leo Stringa.
Thank you, Your Honor. Today is the date and time set for both cases. We have reviewed both the pre-sentence investigation reports and do not have any material corrections. And as to the recommendations for each case, we would respectfully request the court follow them.
Is there anything you want to say before the court imposes sentence?
Oh, yeah.
In the case ending in 1106, sends the court $125 statutory fee, $251.80 restitution to Byer, payable through the court. That will be due 60 days after release. I will order 93 days in jail, credit 62 days. The balance the defendant is due. On the other matter, that ending in 0612, $125 statutory fee, $107.94 restitution to TJ Maxx, payable through the court. That will also be due 60 days after release. And then I'll order 93 days jail, credit 62, the balance.
In this courtroom, excuses don't carry weight. Effort does. The law gives structure, but change is a choice each defendant must make. Today's rulings draw a clear line between mistakes and responsibility.